Now, a live look outside the Supreme Court in Washington, D.C. And right now, President Donald Trump is on hand as justices hear oral arguments considering whether the president's efforts to ban birthright citizenship is constitutional. And this morning, Northwestern University law professor Paul Gowder joining us with more on what will likely result in a historic ruling here. Good morning to you.
A pleasure to be here.
Thanks so much for joining us. Now, you've said that the debate over birthright citizenship is really a debate over the intent of the Constitution itself. So what is the Supreme Court really deciding here beyond immigration policy?
So the birthright citizenship clause of the 14th Amendment was one of the signature achievements of Reconstruction and of the abolition movement. And if you actually look at the history, the Black Americans from both North and South who fought for this really understood there to be a universal principle of citizenship that they were defending. And so the question of whether this extends to undocumented immigrants, although it's before the Supreme Court, really the much broader principle on how we understand it is what the court is going to have to wrestle with.
Now, if the court were to accept a new interpretation of the 14th Amendment and abolish birthright citizenship, some children could end up in limbo. Some adults could end up in limbo with their citizenship revoked. What real-world consequences could we see as a result here?
Limbo is a very good word for it. Another word would be chaos. So even though right now the executive order that Mr. Trump issued only says that it's effective 30 days after the order is implemented, if the Supreme Court actually undermines the universal principle of citizenship in the 14th Amendment, then there's nothing preventing Mr. Trump or Congress or anybody else from going back and issuing another retroactive rule saying, oh, by the way, this now applies to everybody whose parents were undocumented immigrants or temporary visitors. And if that happens, then potentially millions of people could find their status unsettled.
Now, this was, as you point out, an executive order, and President Trump has signed dozens of them, the latest restricting mail-in voting, which will end up in court. How much power does the president actually have, according to the letter of the law, with such an order?
Very little. So executive orders, the way that I like to think of them is they're memos from a manager to their subordinates. In other words, by executive orders, the president can do two things and two things only, maybe three things. One, issue orders to his subordinates, I order the Secretary of Defense to go and do something that's within their power. Number two is do things that Congress authorized. So Congress can delegate power to the president by statute, and if so, then sometimes those can be executed by executive orders. And number three is work in areas where the Constitution specifically delegates power to the president. So, for example, the Constitution, as the Supreme Court has interpreted it, delegates the power to recognize foreign governments or not to the president. And so in principle, he could do that by executive order. But all of these other things, changing the definition of citizenship, deciding what states have the power to do in election administration, none of those are within the president's power.
Well, and to that point, our Secretary of State says that, voter fraud, as he claims, is rampant. Our Secretary of State says it is extremely rare. There have only been a few cases over the last 43 years. So in terms of that executive order that was just sent down and the way we change voting, isn't this a state's issue as opposed to a federal issue?
It absolutely is. And while the federal government has some authority over how states conduct federal elections, that authority, again, is in the hands of Congress, not the president. And in the absence of congressional legislation, the states get to decide how they administer even federal elections.
One last one for you. So with a conservative supermajority in the Supreme Court, could that reinterpretation of the 14th Amendment change how we interpret other constitutional rights going forward, and how?
Well, I don't actually think that the Supreme Court is going to accept the president's reinterpretation of the amendment. If you look at the other conservative rulings that the court's made, they've typically been on things where there was a genuine debate, number one, and number two, where there's been genuine conservative consensus, where the conservative legal movement for a long time has been trying, for example, to overturn Roe versus Wade. Here, conservatives are not only divided, but most cautious, careful, conservative originalists, whether on the bench or in the academy, have said, actually, this executive order is wrong. It's a misunderstanding of the history of the 14th Amendment. And I think that the justices are going to make that clear when they rule.
Well, we will find out, probably get a ruling on that by this summer. Northwestern University law professor Paul Gowder, great insight this morning. Appreciate you very much.
Thank you for having me.